If I'm in an auto accident and I'm partially at fault, do I still have a claim?
Well, the short answer is yes, you still have a claim. Florida is a comparative fault state, so even if you have some fault, you're still able to collect the portion of damages that you weren't at fault for. For instance, if you're 50-50, a jury determines that you're 50% at fault and the other side's 50% at fault, your damages just get reduced by 50%. However, there's a new change to the law that happened about 2 years ago now that says that if you're more than 50% at fault, you get nothing. But that's why you speak to an attorney. It's our job to prove that you weren't at fault or that your fault was limited.
And Gene, does that new 50% rule, does that apply to auto accidents, premises liability, slip and falls, and those sorts of things as well?
Yeah, any negligence case, any case in which somebody owes a duty to you and because of their negligence, you were injured.
Well, and the important thing too, right, is that's an arguable point, right? So when you're talking about whether you're more than 50% or less than 50% at fault or how much your fault is, that's kind of a subjective thing. There's not an exact formula for that. So just as Gene said, make sure you talk to a lawyer and get real legal advice before you start making real legal decisions. And remember, you're getting free legal advice, so you really need to talk to an attorney before you rely on each and everything that we talk about tonight, right, Gene?
Not a bad idea. It's always good to talk to an attorney.
Always.